right, welcome back, Consumer Law 101 viewers. We are here today on our 8th advanced video entitled The Truth About Repossessions and How to Get Them Removed. As always, I'm your course instructor, Attorney Aaron Swift. I'm the managing partner and CEO of Swift Law North and also managing member and owner of Swift Law South. Don't mention it as often, but that's our flagship down here in Florida and kind of the blueprint of how we're building the national network. All right, let's get to today's agenda. So first, we're going to talk about the truth about repossessions. Much like our last two topics, the misunderstood topics from the last video, 1099s and charge-offs, repossessions are incredibly misunderstood. There's a lot of misinformation, purposeful and not. So we're going to talk about the truth. Then we're going to talk about how to get repos removed in an appropriate way, the legal way. And lastly, as always, end with best practices. Okay, so the truth about repossessions. As it mentions here, repossession is one of the most misunderstood credit reporting events. Simply put, a repossession is the seizure of an asset that secured a loan because there's a default on the loan. So that's in a roundabout way. Cars are the most common assets that get repoed or that consumers regularly deal with in the repossession realm. And so, in that way, it would be the seizure of the car. That's the asset, the collateral that secured a loan. That's the car note because there's a default on that note. Um, other things can be repossessed: boats, motorcycles, electronics, furniture, jewelry. I talked about in an earlier video water softener systems. Generally speaking, if the laws and rules are followed, again, then repossessions are legal, just in that simple framework. If there was a valid loan, and then if there was a default on that loan, if the asset was not enough to secure that loan, it's generally repossessed and then sold. Um, there are so just blatant lies and misinformation saying that repossessions in general are illegal or they can't be credit reported or there's no such thing as an assignment from a risk and all these other incredibly ignorant and harmful things that people in this space tell consumers. But just go back to the basics. A repossession is simply that. Let's just talk about a car. There's a car note. Let's assume that's valid. If there's a default on that note, then the asset, the collateral, the car, it's repossessed. And then generally speaking, it is sold. If that sale isn't enough to cover the entire loan, then there's a deficiency owed. Um, Again, you see a lot of crazy things online about credit repair and repossessions and how you can get all of them removed because they're all illegal. That's nonsense. It's not a true statement. A lot of people are making things up or getting bad information and perpetuating it, and it gets consumers into a lot of trouble and harm. Again, I've seen videos go as far as to say that you can basically all cars can be free as long as you get a loan because there's no such thing as a legal repossession. Well, again, that's just nonsense. So moving on, repossessions can be voluntary and involuntary. The distinction is important in terms of credit reporting. So I would say if you are on the verge of a repossession, no matter what, and there are no other ways to stop it, I would commend consumers to volunteer, to act in a voluntary way by coordinating pickup times, coordinating keys, coordinating picking up of personal property, so on and so forth. Especially if it's voluntary, it helps because repossessions cannot breach the peace. That's one of the biggest issues that we see is certain repossession rules that aren't followed, whether that's by the repossession agent, usually the towing company, or others in the space. And in fact, repo agents can even qualify as debt collectors under the FCRA and FDCPA in certain circumstances. I'm actually going to add that in live because that's important as a distinction um, as we talk about the protections that can be afforded to consumers. So, um, the last thing I want to talk about repossessions is that repossessions require a series of important letters. and certain industry standards must be followed when selling a repossessed asset. So let's talk about really in brief those letters. So first of all, prior to a repossession, there has to be notification to a consumer in writing, and it has to be sent a certain way and include certain information, namely that there is an impending potential repossession, that that's because of an alleged default. It has to tell you ways to cure that default to avoid the repossession. So that's a required letter under laws called the UCC, the Uniform Commercial Code. Next, after, let's assume that the first letter was sent and the consumer did not clear the default in time, then the collateral is repossessed. And let's just assume right now is repossessed lawfully and without a breach of the peace, without a breach of the peace. So then a lender or whoever is servicing, the loan on behalf of the lender, if there's a servicer involved, has to send a letter post repossession that offers a couple of options. One is now you have another opportunity to clear the default, but it can include the extra costs of the repossession and fees, other things associated with it. You can also arrange within that communication a way to get the personal effects back. That's important. One of the things, because if there's an involuntary repossession or even voluntary, sometimes things are forgotten. It's important that consumers have an opportunity to get their personal effects back from cars. And, sometimes people keep very important things in their cars. I don't recommend it, such as wallets, birth certificates, social security cards. We're going to talk at some points about common violations, and identity theft is one of the biggest issues. So I wouldn't recommend those things, but again, it would be important for a repossessed vehicle to have an opportunity to get those things back. So that's one of the letters. That's the second and third of the three required. And then after, there has to be an auction or some sort of a reasonable manner to dispossess of the collateral and basically sell it. Then what happens is a letter is sent if and when to explain what the accounting is after the auction. So in most cases, there would be what's called a deficiency owed, because at an auction, you're usually going to sell the collateral for much less than is owed on the loan. And then the letter has to give certain information about the deficiency. In some rare circumstances, it could be that collateral would be worth more than the loan. In that case, after the loan amount is paid and all other fees associated with, the tow and the repossession, then the surplus would be owed to the consumer. But nonetheless, a third letter is required, and that has to kind of give the accounting of what happens after they, sold, got rid of the collateral that was repossessed. All right, so let's turn to an important topic, the truth about how to get these things removed, because I know repossessions are one of the bigger derogatory remarks on credit reports. And so credit repair companies get a lot of questions, and obviously consumers themselves have a lot of questions about, repossessions and how to get them removed. So we just go back to the basics, what are the standards for accuracy and what can be disputed? Um, the first things you want to do is carefully review the repo account and that debt across all available, credit reports. Is it being reported consistently and accurately? Is the repo date reported consistently and accurately? One of the things you also want to know is, did the lender or servicer send those required three letters? Here's one of the most powerful things. If the lender or servicer did not send those letters, now, and they can send them to the last known address, so as long as they sent them to a reasonable address, they get to check a box, but they don't often send them all. So if it can be shown that the lender or servicer did not send one of those three required letters under the UCC that I talked about, then no deficiency can be owed on that vehicle. And so what that means is then the credit reporting would have to show a $0 balance after the auction, not whatever alleged deficiencies owed. So that's a huge issue, something we look for, and that's a lot of leverage to get repossessions removed from credit reports is when they get that wrong, because that's one issue we can dispute, and then as part of the settlement, get the trade line deleted often. Next, we want to look, is the repossession illegal? Um, as I said, repossessions cannot breach the peace. Not going to go into all what that means, but there are certainly some standards in every state that you can look into. They certainly can't take a vehicle by force. They can't get into a physical altercation with a consumer. You cannot repossess or tow a vehicle with a consumer in it. That happens now and then. I've had a horrible case when a repossession took place, and the baby was in the car because they took it. Someone was in a convenience store. Um, yeah, that's a bad problem. But there are other opportunities where repossession can be illegal. If they came behind a locked garage, they can't break down doors. They can't get behind locked doors. So that's one of the things we're going to look at. If the repossession was illegal, then the deficiency is not owed. And again, so that can be a way that we can dispute and then sue over. And then lastly, we just want to know if the facts about the account are reporting consistently and accurately. If it's been repossessed, it has to be listed as closed. And so once it's closed, you no longer send monthly statements, so you can't add contractual interest and fees any longer. So that's one of the things we're going to look for. And one of the ways we can get repossessions removed is because they often keep charging fees and interest that they cannot on top of after taking the vehicle. So again, if any of this information is inaccurate, incomplete, or inconsistent, then we dispute, and then sue. And that's how we get it removed. That kind of then ties into our consumer best practices. So what we want you to now understand is at least the basics of what a repossession is, how it works in kind of a very general framework, at least understand the steps and what information is sent to the consumer as part of those steps. There's so many falsehoods in this space about repossessions online. Again, beware of any outlandish claims, including that the repossessions themselves are illegal and then every consumer can get them removed in a free vehicle. That's just kind of outlandish. Um, and if we can identify some Fair Credit Reporting Act violations as it relates to these accounts, then it'll help us fight back. We can dispute those issues with more information in later videos about how to dispute the dispute process, including our lawyer drafted templates that we highly encourage if consumers are going to do this on their own, that they do so, at least with that fresh start. Yeah, if you have questions about repossessions on your reports, if you think that a repossession may have been illegal, or you have questions about whether or not you received those required UCC letters, one small caveat and kind of trick of the trade in that instance, a lot of times the lenders or servicers do not send those letters to co-borrowers or co-signers, and that's a problem. Um, so if they only send it to the primary borrower, then that person may be liable for a deficiency, but the co-borrower may not. So that's one interesting aspect that we can look into. And if we find that's been the case, then we can definitely get the deficiency to be reported correctly, and in all likelihood get the whole trade line removed, which is the point. So as always, if you would like some more educational content, please visit www.consumerlaw101.com. Remember, the basic videos can be found there. You're in the advanced series, about the end of it. The pro series is even better, more knowledge. And again, what those videos include our lawyer drafted templates that I would recommend any consumer use if they're going to go at this on their own. And then conversely, if consumers want help, if you've identified clear errors on your credit report, if you know there's an issue with a repossession and it's reporting incorrectly, reach out to us at swiftlawnorth.com. We'd love to help. So, thank you.